Hi everyone, this week's video follows on from a question we received from a client in a live situation. How exciting. And it relates to the payment of statutory sick pay in circumstances where an employee may not have complied with certain requirements. And there is an important distinction to be made within this video, which we will come to. So to receive SSP in simple terms, subject to ordinary other qualifying criteria, some of which relates to average pay, for example, employees must notify their absence to the employer and must submit evidence of incapacity as agreed with their employer. So looking at notification to start with, the default procedure, if there's nothing contained in the contract, is that an employee or their representative must inform the employer of any date they're unfit for work within 7 calendar days of that date. If the employee notifies outside of that 7 days and the employer does not accept that there's good cause for that delay, SSP can be withheld. And this is where we'll come on to the distinction later. It's common for employers to introduce more onerous requirements. Of course, if you had to wait 7 days to find out somebody was sick, that wouldn't be very helpful. So often in the contract, it says, for example, an employee has to ring in 1 hour before the start of their working day. There may be other restrictions, text messaging not acceptable, can't use a third party to report that absence. That doesn't override the statutory regime for the purposes of SSP. So if an employee doesn't ring in directly or rings in after 9:30, for example, and that's your rule, you can't withhold SSP just because that rule has been breached. But for company sick pay purposes, you can put whatever notification rules in you like, and if the contract is drafted in such a way that sick pay can be withheld, company sick pay can be withheld if the notification requirements are not complied with, that's absolutely fine. We then move on to evidence of incapacity. So we've done notification, we're now on to evidence. An employee should provide a self-certification form for the first 7 calendar days of absence or less. So this is a signed statement from the employee only. No need to introduce medical experts at this time, just giving a brief rundown of their incapacity. For longer absences of more than 7 days, a doctor's note now has to be provided. So it's now been rebranded as a fit note or a statement of fitness for work. Now, technically, employers are free to decide what evidence they require from an employee in terms of their incapacity. But again, just as with the notification requirements, for SSP only, they can't insist on a doctor's certificate for the first 7 days. I've not come across a business that does for company sick pay purposes as well, because typically the GP will charge for that note. But after 7 days, the employer can insist on a statutory fit note or other reasonable evidence. In practice, it's the fit note that's required for SSP purposes. HMRC says that it should generally be accepted as evidence of incapacity unless the employer has strong grounds for believing otherwise. I think it's a risk in all cases if a medical expert has given that opinion for an employer to then say, actually, I don't believe it, because typically you won't have medical qualifications yourself. You may accept a different type of evidence that's been provided. So, for example, a note from a foreign doctor for an illness diagnosed abroad, or a certificate from a herbalist or acupuncturist in some circumstances. HMRC's guidance on the position states that if you are provided with an alternative and you have doubts, you can ask for a fit note. You can send the employee to occupational health, or there is medical services, which is a contract that the DWP has with HMRC to determine fitness for work. So we now come back to the question of what happens if I want to withhold SSP from my employee. So 2 scenarios, and this is where the distinction is made. If the employee notifies you of their absence late, so more than 7 days after the event, you can withhold SSP for the period of the delay in notifying. However, if the employee notifies you of their incapacity within 7 days of the absence starting, but doesn't provide a medical certificate until 3 months down the line, but that medical certificate covers them from their first day of absence, which is quite common, unfortunately. Doctors do that retrospectively, which I find quite bizarre. In those circumstances, you can't withhold SSP, because the only way to withhold SSP is for a delay in notification and not a delay in certification where notification has been made. So there are some proposed reforms of SSP going forwards, none of which have been taken up. There is always pressure from some in government to increase the amount payable for those who are off sick through no fault of their own. There is a proposal to phase sick pay in as employees make a phased return to work, but none of those have been taken forward. The Work and Pensions Committee on the 9th of November have commenced a new inquiry into SSP though, and we await further news there. I hope that's helpful. If you need any further support or assistance on this, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.